Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Good morning, everyone. My name is Jessica Paglia. I'm joined by my fellow associate at SpringLaw, Jeffrey Adams, and we're here to talk about progressive discipline and termination and a good process for building defensible systems in your own workplace. So with that, that's us. So for those new to our webinars, welcome. We're a virtual Canadian law firm specializing in employment and contracts law. Feel free to ask any questions throughout the presentation, the webinar, in the chat. And if we can't get to your comments, please feel free to follow up with us afterwards. You can download the slides under the Handouts tab. And for more resources, feel free to visit our website at springlaw.ca. You'll find our award-winning blog with weekly updates, a free policy compliance checklist, a link to subscribe to our monthly newsletter, and more information on our subscription program for employers and do-it-yourself legal products and things of that nature. So before we begin, we would like to acknowledge that the land on which we operate is the traditional territory of the Anishinaabe, Haudenosaunee, Huron-Wendat, and Mississaugas of the Credit First Nation who have stewarded these lands for generations. We recognize that Indigenous people lived and thrived here long before the arrival of settlers, and we acknowledge the lasting impacts of colonialism. As part of our commitment to truth and reconciliation, we strive to learn, unlearn, and understand the history and effects of these wrongs, and we are grateful to live and work on this land. So today is all about legal information and not legal advice, but we are lawyers, so no talk is complete without some sort of disclaimer. So here's our disclaimer. I'll leave it on the screen for a moment. Okay, and you can also review that in our slide packet. So today, here's the game plan. We're going to start with the basics, what progressive discipline actually is and why it matters. And then we'll go into the legal side of things, including key laws and employer obligations. From there, we'll walk through the step-by-step process of progressive discipline. We'll talk about the limits to progressive discipline and discuss when warnings might not be enough and what to do in those cases. And finally, we'll wrap up with some key takeaways and best practices so that you leave with practical strategies that you can apply right away. And with that, I'll pass it to Jeff to give us a better understanding of progressive discipline. Jeff, I can't hear you.
Sorry about that. I was trying to use my space bar technology. Thanks very much, Jessica. So today, part of what we want to do is clear up some common misconceptions. Progressive discipline is really about giving employees a fair chance to improve, while at the same time ensuring that you as employers are protected. And it's not about punishment. It's about setting expectations, having clear conversations, and most of all, keeping good records. And you'll hear us repeat over and over again, document, document, document. Now, if done right, progressive discipline can help avoid what can be messy legal disputes, and ensure fairness across the board. So we'll break it down step by step so you know exactly how to deal with it in your workplace. So to reinforce this idea of progressive discipline not being punishment, it's not just about handing out warnings. It's a structured, step-by-step approach that ensures employees know what's expected and that employers have a defensible process in place. If done right, it minimizes risks, legal risks, and sets clear expectations for everyone involved. Now let's look at what progressive discipline is not. So it's not every workplace process falls under the umbrella of progressive discipline. An example is performance improvement plans. They're about long-term growth and improvement, not immediate discipline. Accommodation reports and harassment investigations. These are legal obligations under human rights laws, not disciplinary tools. Coaching and mentorship, another good example. It's about development, not correction. And discipline should never be about punishment or retaliation, but always to be corrective and legally sound. It's about getting employees to be good employees. And mixing these up can lead to some serious legal trouble. Over to you, Jess.
Thanks, Jeff. So before we get into the steps of progressive discipline, we're going to talk about the framework that employers need to keep in mind, the legal framework in particular. So a discipline process isn't just about setting internal policies. It must align with employment laws to avoid any legal risks when carrying it out. The Employment Standards Act sets out minimum standards for things like termination pay, notice periods, and sets out a threshold for when those entitlements don't apply, but it doesn't actually require progressive discipline in order to terminate an employee with cause. But under common law, courts expect employers to apply fair and consistent discipline before terminating an employee for cause. And without a proper process, a for-cause termination can easily be challenged. And often, as we see, the employer loses. And then there's the human rights law considerations. The Ontario Human Rights Code and Accessibility for Ontarians with Disabilities Act both impact how discipline is applied and carried out. If an employee's misconduct is linked to a protected ground under the Human Rights Code, things like disability, family status, religion, creed, employers have a duty to accommodate before taking disciplinary action, and ignoring this duty to accommodate can lead to some costly human rights claims. So the key takeaway here is that discipline has to be fair, well documented, and compliant with these legal requirements. Otherwise, an employer could face wrongful dismissal or human rights complaints. So now we're going to talk about just cause termination. And it's sometimes referred to as the capital punishment of employment law, which is dramatic, but it's because it's the harshest penalty an employer can impose. When an employee is fired for cause, they don't receive their notice or severance or a lot of their other termination entitlements. So because the consequences are so serious, the legal bar for just cause and for enforcing just cause is extremely high. So there's no single definition of just cause. Under the ESA, just cause terminations mean that the employee loses their right to notice or termination pay. But the ESA sets a very high bar. So there's, a sentence in the regulations, it's only willful misconduct, disobedience, or willful neglect of duty that's not condoned. And we'll get into the specific language, but it's a very high threshold. And only certain situations meet the standard. And the misconduct must be intentional, not just a mistake or continued poor performance. And courts look at each case individually, considering factors like the nature of the misconduct, the employee's role, and whether progressive discipline was used. And what qualifies as just cause in one situation may not in another. So some examples of misconduct that could be qualifying as just cause are theft, fraud, workplace violence or harassment, very serious insubordination, repeat performance issues after multiple warnings, conflict of interest or breach of confidentiality issues, or things of that nature. But even with the most serious misconduct, courts expect employers to act fairly and proportionately in each situation. And the burden of proof is on the employer to show that just cause existed. So if a case does end up in court, if a termination is challenged, judges typically lean in favor of the employee unless there's very strong evidence that a termination was justified in that particular circumstance. So if an employer gets this wrong, they could face a wrongful dismissal claim, and it can lead to some significant damages. And because of the high stakes, employers need to follow a very diligent and fair process. So this includes things like conducting a proper investigation, giving the employee a chance to respond to the allegations, considering whether a lesser discipline is appropriate in the circumstances. Skipping these steps can weaken a just cause case and can really increase legal risk for the employer. So the bottom line is that just cause is possible, but it's very difficult to prove. And in most cases, progressive discipline is the safer and the more effective approach. So now we're going to look at how the process works, and I'll pass it over to Jeff to discuss the steps of progressive discipline.
Thanks, Jessica. And just to follow up on this idea, courts have held that the threshold under the ESA is very, very high. And there's a decision called Plester where the court actually said that the intent, where it's willful misconduct or willful negligence, has to be almost the same as criminal intent. So just to reinforce how high that threshold is, I was on a case a couple of years ago where one employee shoved another employee during work time, shoved her into a case, and that wasn't enough. Like we won the case in that we kept her. We insisted on keeping her terminated, and the judge agreed. But the judge also said that it wasn't intentional because it was in the heat of the moment, and it's such a very high bar. So please, if you are considering terminating for cause, get in touch with us and let us do an evaluation. Sort of look before you leap. Now, in terms of how to address these real discipline issues, there are steps to progressive discipline, and this progressive discipline follows a structured, step-by-step approach, and it's to ensure that fairness and consistency are in handling workplace issues is front and center. The process typically starts with a verbal warning, followed by a written warning if the issue persists. So if the behavior or performance doesn't improve, the next step could be a suspension, and the final step, if all else fails, can be termination. But the goal at each stage is to give the employee a clear understanding of the issue, what needs to change, and especially important are communicating the consequences of what might happen if they don't improve. And throughout the process, as I mentioned before, documentation is critical. If it's not written down, it didn't happen. And so we'll break down each step in more detail in the next slides. So some of the key principles that make progressive discipline work are fairness and consistency, first of all. So if similar situations aren't handled the same way, you open yourself up for legal risk. And this can be just accusations that you're favoring one employee over another, possibly based on a human rights ground. It's handle everything similarly, similar situations similarly, and it will reduce that risk. The second, and I told you I was going to mention this a lot, documentation. So without records, it's as if it didn't happen. You can have, once you have something documented, it makes our job in defending you much easier. Third, clear communications, and this is common sense. and also legal advice, but employees really need to understand what's wrong and what's expected of them. It can clear up a lot of potential legal issues. Finally, employees absolutely should always be aware of the consequences if they don't improve. And I've had a number of clients where they follow everything exactly right up to the last step, and they don't warn the employee of the consequences of, your job may be at risk here if you don't improve, and that's fatal to trying to terminate someone with progressive discipline. So keeping these principles in mind, helps ensure that discipline is effective and legally sound. So we'll go to the first step, as I mentioned, is a verbal warning. And this is a little counterintuitive because even though it's a verbal warning, it should still be documented. So, a quick note into the employee's file, the date, the issue, what was discussed. This makes a huge difference if issues continue. And the conversation should be clear. Like I said, here's the problem. Here's what needs to change. Here's what's going to happen. Here's what's going to happen if it doesn't. So simple, fair, clear, and documented. And the second step, if a verbal warning doesn't lead to improvement, the next step is a written warning. Some employers do two verbals and then a written, but if they're not improving after a verbal, I always advise to progress things to a written warning. And this is where the documentation becomes even more critical. So a written warning has to clearly outline the issue, the previous discussion, the expectations, and the consequences. And the tone is really important. It has to be professional and focused on improvement, not punishment. And a good way to structure these is to assume that anything that you write is going to be read by a judge. You got to avoid vague language, be specific about what the issue is and what needs to change. And again, the goal is to set clear expectations and create a documentary record that supports you as an employer if further action is needed. It's important to have the employee acknowledge receipt of the warning. Ideally, they do that by signing it. If they refuse, note that on the document. And that ensures that there's proof that the employee was aware of the issue and expectations moving forward. It's always good to have a couple people in these conversations if possible. Then I'll turn it over to Jess now for the next steps in the process.
Thanks, Jeff. So now that Jeff has explained verbal and written warnings, the next level of progressive discipline is suspension. And suspensions are typically used when previous warnings haven't worked, or when the misconduct is serious enough that a stronger response is needed, but not so severe that a termination is justified. So examples of this might include repeated insubordination that has escalated to the point of a suspension being considered, some serious policy violations, or workplace misconduct that might require an investigation. So when regarding paid versus unpaid suspensions, this is where things get kind of tricky because paid suspensions are generally lower risk because the employee is still receiving their wages. And so paid suspensions are often used when an investigation is underway to keep an employee off site while the employer can gather more facts and understand more clearly what happened. Unpaid suspensions, on the other hand, can be a bit risky unless there's a clear policy allowing for unpaid suspensions. The courts may see them as an employer unilaterally changing the terms of an employment relationship. And this could potentially lead to constructive dismissal claims or complaints. So before imposing an unpaid suspension, make sure that your employment contracts or policies allow for it. And if you don't have any policies in place, or if you're unsure if they're compliant or include this particular language that would allow you to have an unpaid suspension in place, we have legally compliant templates that cover these essentials, and we can also look through your policies if needed to ensure compliance and to ensure that you have the most protection available to you as an employer. So feel free to contact us after this webinar if you need help with that. So the key to any suspension is clear communication. When informing an employee of a suspension, make sure that you ensure, if possible, that there are we do recommend, that you ensure, if possible, that there are two management side people in the room. This is if possible. Again, like sometimes the workforce doesn't allow for it, but this would typically be someone from HR as well as an employee's manager or supervisor, whoever is kind of holding that role. And this can ensure for you, the employer, that there's a clear account of what's happening, and that any notes from the meeting can be corroborated if ever needed. So it's always best to have two people in the room if possible. So you can be direct, explain why the suspension is happening, reference past warnings, if applicable in the circumstances. Be sure to outline the terms of the suspension when communicating to an employee. So is it paid? Is it unpaid? What policy is being relied on? How long will it last? What's the pending, if there's like a pending investigation, ensure to mention that as well. Set expectations. So make it clear what the employee needs to change when they return. Again, as Jeff mentioned, this is very important to mention that the employee must improve, and that if further misconduct happens, termination may be the next step. And then again, you'll hear this 1,000 times in this particular webinar, but document everything. Always follow up with a written notice confirming the suspension details. Have those two people in the room, or even that one person in the room, make very diligent notes about what they covered, what the employee understood, what they refused or didn't agree to. Just make clear documentation. It will be very effective, much more effective than memory, and much more compelling than memory. And then suspensions can be an effective tool, but only if used properly. Misusing suspensions, especially unpaid suspensions, can create a lot more legal risk than they actually solve. So if your disciplinary action gets to this stage, it's always a good idea to review your policies prior to any decisions being made and to seek legal advice before moving forward. So next, we're going to talk about the final step in progressive discipline, which is termination.
And just let me just jump in here. My advice often to employers is, once you get to this stage and you're having meetings, assume that it's being recorded. Employees often will surreptitiously record conversations because they know that their termination is looming. And so assume it's being recorded, make sure your notes are accurate and line up with the conversation. And I often say, record it. Like, don't do it surreptitiously, because there's no, you don't need to. You can say, this meeting is important. We're going to record it to make sure there's no debate about what happened in the meeting. And then, and that also helps the employee know this is serious. This could have repercussions on your employment.
Thank you, Jeff. Yes, very, very important point. We've gone through verbal warnings. We've gone through written warnings. We've just touched on suspensions. So now we're going to talk about the final step, which is termination. And it's never an easy decision, but when progressive discipline hasn't worked, or the misconduct for the situation is serious enough, termination might be necessary. And it should only come after the employee has been given clear opportunities to correct their behavior in most circumstances, unless the misconduct is so severe that an immediate termination might be justified. And some common reasons for termination at this stage may include repeated performance or behavioral issues despite several prior warnings and despite following the progressive discipline steps, serious policy breaches, or misconduct that fundamentally breaks trust between the employer and the employee, things such as theft, harassment, things of that nature. And at this point, and at every point, documentation is critical. If there's no clear record of past discipline, the termination could be challenged, and the employer could be on the hook for some significant damages if this procedure isn't followed correctly or if it isn't justified in the circumstances. So, to ensure procedural fairness, even if a termination seems justified, it has to be handled properly. So this means conducting a fair investigation, make sure you have all the facts before making a final decision, and make sure that you're making that decision with an unbiased eye. Giving the employee a chance to respond. So the employee should be able to explain their side of the story. Sometimes things have a way of coming out when an employee is discussing why they did what they did, things that could lead to obligations regarding the duty to accommodate or things of that nature. So ensure that you're giving the employee a chance to respond in these situations. Ensure that you're following your company policies and the employment contract if applicable. If you have a termination clause specifically for that employee in their employment contract, ensure that you're complying with it and providing proper notice or severance. So, as Jeff mentioned prior, unless it's a just cause termination, which, as we discussed, is very difficult to prove, the employee would be entitled to notice or pay in lieu of notice under the Employment Standards Act and potentially more under common law, depending on how limiting your termination clause is in your employment agreement. So, the key to this is avoiding wrongful dismissal claims. Wrongful dismissal claims happen when an employee believes they were fired unfairly or not given proper notice or termination payments. So to reduce this risk, ensure the termination is well documented. If an employee was warned multiple times, keep records of all of those warnings. Be professional and be respectful in the termination meeting. A poorly handled termination can and often does lead to a legal dispute. So ensure that whoever's conducting the termination has a script that they follow. We can help with that as well. And consider offering a termination package regardless of the nature of the termination that would be consistent with that employee's ESA entitlements. So a reasonable severance offer can help avoid costly litigation in the future.
Let me just highlight some overlap here. Like these discipline issues can often be signs that an accommodation may be required. And under the Human Rights Code, there is a duty to inquire. So if someone's been late, 10 days in a row, you may have to, before you think about disciplining, ask them why, and that's part of the duty to inquire. Say, is there a problem with your, you've been late 10 days in a row. I'm exaggerating for making the point, but, ask them why and ask them if they need an accommodation to correct the behavior. So it covers you on a bunch of different fronts, particularly when it comes to the Human Rights Code and needing to make accommodations.
For sure. Thank you, Jeff. Next, we're going to talk about just cause versus without just cause and how to terminate in that same line of discussion. So as a reminder, just cause termination means no notice and no severance. And the burden of proof, as we've discussed, is very high. Courts rarely uphold just cause terminations unless the misconduct is serious enough to justify it and is well documented in the circumstances. And if an employer doesn't get this right, they could face a wrongful dismissal claim and then be ordered to pay significant damages. And under the ESA, as we've discussed earlier, an employer can terminate without notice or severance only if the employee is guilty of willful misconduct, disobedience, or willful neglect of duty that is not trivial and that is not condoned by the employer. And there's a lot of nuances to that sentence. And it's a much higher bar than common law because the misconduct must be intentional, can't just be poor performance or negligence. that is not repeated or things of that nature. Not condoned means that it can't have happened before, and the employer just said, whoops, okay, we're not going to address that one, but we'll address the next one. It has to be um, very, very grounded in that it's willful misconduct, disobedience, willful neglect of duty that is not trivial and that is not condoned by the employer. Now, that's the ESA standard, whereby a for cause termination would be accepted. Common law just cause is much broader and more flexible and considers more circumstances, including the nature of the misconduct, the employee's role and length of service, and whether progressive discipline was used in the circumstances. And courts often require a proportional approach, meaning that minor infractions usually don't justify termination for cause. And so without cause, it's a lower risk, but it comes at a cost. So most terminations are without cause, um, or that we see kind of carried out are without cause. And that means the employee might have done something, but not enough, not serious enough to justify an immediate dismissal. So in these cases, we recommend providing notice or severance under the ESA, and potentially you would have to provide more under common law unless you have a valid termination clause in your contract. So if there's any doubt about, if a certain situation constitutes just cause, or, if the employee's particular circumstances would warrant a with cause termination, a without cause termination with a fair severance offer is often the safer and more predictable option, because a misstep in a termination scenario can be very costly. We also recommend proper planning. Ensure that you're approaching these situations with a lot of thought going into it prior to actioning anything, and seek legal advice prior to actioning anything as well. So now we'll turn it over to Jeff to discuss the considerations, limits, and warnings.
Thanks, Jess. And just to drive the point home, we'll go back to this case that I was representing the employer. There's a way to dismiss at common law for cause, when even though it may not rise fully to the standard required by the ESA. So in the case that I was on for the employer, the employee shoved another employee, so there's violence, and we were able to dismiss at common law while still paying the ESA entitlements. And the judge decided it was important for the employer to say, if there's any instance of violence, you're terminated. So we won in terms of that element. But just to highlight the fact that there's a very different standard at common law versus under the ESA. Same is true of even theft. If the theft is trivial, so that's the willful misconduct, disobedience, willful neglect of duty, that is not trivial. So if they steal $10, is that too trivial? Possibly. If they steal $1,000, we're in a different conversation. But it's, like Jess said, it's very, very nuanced. So just to drive the point home that termination for just cause is tough. Under the ESA, the bar is extremely high. If you get it wrong, you're gonna face, you're very likely going to face a wrongful dismissal claim. Most terminations are without cause, meaning that the employer has to provide either notice or severance termination payments in lieu of notice. And like I said, just cause terminations are very difficult to justify because the legal threshold is very high. At common law, just cause requires serious misconduct that fundamentally breaks the employment relationship. So a single instance of violence, if it's severe, is probably enough. Maybe not. The courts it's so tough to guess what they're going to decide. But if you can't prove just cause, the employee is entitled to reasonable notice or pay in lieu. So we've talked about this. I don't want to beat a dead horse, but there's a famous case, a key case on the issues of render and decent group elevator. And in that case, the employee committed an act um, of violence and of sexual harassment and sexual harassment or violence, really. He slapped another employee on the buttocks. And even like I read the case and I was like, come on, man. To me, that should have been enough to terminate under the ESA. The court said no, it wasn't intentional. It was done in the heat of the moment. It was done in jest. And they split, it was a bit of a Solomon's baby decision where they awarded the employee ESA termination entitlements and extinguished their common law entitlements. So you can see, like, even in cases where it seems obvious, please seek legal counsel before you decide to terminate with cause under the ESA. So next, if just we can progress to the next slide. So I want to touch on the difference and distinction between performance management and discipline. They often get confused. They serve very different purposes. Performance management, like performance improvement plans, it's about coaching employees, it's about long-term improvement, whereas discipline is about addressing specific incidents of misconduct or policy violations. And again, just made this point, I'm going to reinforce it. It is so important to have policies that the employee has been given in advance that you can point at and say, look, we told you not to do this. You did it. Here's the repercussions for that. But using the wrong approach in the wrong situation, not having effective policies in place, they can just create enormous legal risks. So knowing when to use each tool is absolutely critical. And before you discipline an employee for misconduct, you must investigate. So if you skip this step, you risk acting on bad information, or worse, looking unfair or being unfair. And a solid investigation means gathering facts, talking to the right people, giving an employee a chance to respond. An example of this, there's a case where a senior manager was caught on camera taking gifts out of, a holiday basket that was being kept in the lobby of the point of sale location, and the managers above this employee thought they'd caught him stealing. What he was actually doing was taking the gifts away for the lunch hour to make sure they were safe, and it was intending on putting them back. Whether or not that was the story, whether or not that's true is another conversation. But going out and figuring out whether there's a different story, a different version of events is very, very important. And rushing through that can lead to claims that the discipline wasn't justified. And again, whether or not that story is true, the court bought it, right? So that is what you have to use as your litmus test. Again, rushing through it leads to legal problems. And those can include human rights considerations, which Jess is going to talk about now.
Thanks, Jeff. So as Jeff kind of has been outlining, and as we've both been outlining, discipline isn't always straightforward. Sometimes employee behavior is linked to a protected ground under the Human Rights Code, such as disability, family status, religion, things of that nature. So in these particular cases, employers have a duty to accommodate prior to imposing discipline. If an employee's misconduct or performance issue is connected to a protected ground, or even might be connected to a protected ground, such as a medical condition affecting their work, family arrangements that would cause, tardiness or things of that nature, discipline might not be appropriate in those circumstances. And instead, the employer must explore reasonable accommodations, such as modified duties or scheduling adjustments to accommodate these individuals. And skipping accommodations can lead to very costly human rights claims potentially. If an employer disciplines or terminates an employee without considering accommodation, they could be liable for damages, including lost wages, other human rights penalties and damages, and the cost could be fairly significant. Um, so, a way to approach this is, as Jeff previously mentioned, the difference between coaching an employee and disciplining an employee. They're both ways to address performance or behavior, but they serve different purposes. And coaching is more of a collaborative approach, more of a conversation. The goal is to help the employee succeed, not to penalize them. And you can use coaching to support and develop an employee to understand further the accommodations required and to develop a plan moving forward collaboratively. Now, discipline, on the other hand, you can use when the rules aren't followed, when they're broken, when performance doesn't improve after coaching, but it has to be separate from the duty to accommodate. Coaching should feel like a conversation, whereas discipline should be more formal, more structured, and have all the characteristics that we have previously mentioned. So, constructive dismissal risks. And we touched on this very briefly previously. Even if you don't formally terminate an employee, certain employer actions can amount to what's considered a forced resignation. And this is called constructive dismissal. So constructive dismissal happens when an employer makes a significant unilateral change to a fundamental term of employment, forcing the employee to essentially quit. So in these cases, the employee may be entitled to severance just as if they were terminated without cause. So some employer actions that could trigger a claim are major pay cuts or demotions. Major being the operative word, but it might be less than you think. We've seen claims come through for 4 to 5% of a pay change and still be justified in the circumstances. So it all really depends on the circumstances of each situation. Significant changes to duties, locations, or hours could trigger a constructive dismissal claim. Even a toxic work environment, such as harassment or unfair discipline or management tactics, could trigger a constructive dismissal claim. Or, again, as we discussed earlier, unpaid suspensions. If they're not contractually allowed, or even if they are, they could trigger a constructive dismissal claim. So, how to mitigate these risks are to always get employee consent prior to major changes, to use very well drafted contracts, employment contracts, with a lot of flexibility clauses whereby things of the nature of the employer can amend or modify you know, these details at any time or with proper notice. So things of that nature in your contracts. Handle discipline and suspensions carefully and use the tips and tools that we've been talking about. And again, as always, seek legal advice before making any significant employment changes. So the bottom line again is unintentional constructive dismissal can be very costly. So you need to be careful. Employers need to be careful when making these major changes. So I'll pass it over now to Jeff for takeaways and best practices.
All right, we're about ready to wrap things up here. Some of the common pitfalls, common mistakes that can cause big problems for inconsistency. Treating similar cases differently can lead to legal issues, including discrimination claims, poor documentation. If it's not written down, it didn't happen. Rushing to termination. Cutting corners makes our job defending you much more difficult in litigation. Finally, retaliation, even if it's unintentional, disciplining for the purpose of punishment can be, even if it's unintentional, can create major risk. So helping, avoiding these mistakes is part of our job. Helping you avoid these mistakes is part of our job, and keeping the process fair and defensible is something we always strive for. A solid employment contract makes a major difference when it comes to terminations, and a properly drafted termination clause can limit severance obligations only if it's enforceable. And many of you probably know that the courts in Ontario have been uh, uh, swinging wildly at invalidating termination clauses in the last few years. And so that the problem is that the courts are taking aggressive positions, and many older contracts have termination clauses the courts just won't uphold. And that's true even of contracts that are, a couple years old at this point, just because of the way things have been changing. So if your contracts haven't been reviewed recently, now's the time, and we can definitely help you with that. Jess.
Thanks, Jeff. It wouldn't be a proper webinar without, again, a mention of document, document, document. Good documentation is your best defense if a termination is ever challenged. And without it, a wrongful dismissal or a human rights claim just automatically becomes exponentially harder to fight. So, things that should be included in these disciplinary records are dates and details of an incident or performance issues. The employee response, if any, is given, should be documented. Any steps taken, any warnings, any coaching protocol, any suspensions, um, any clear expectations for improvement in the future. So, setting a very clear threshold of what needs to happen for the employee to improve and what's going to happen if the employee doesn't improve, if the issue continues. So, clear expectations as well as clear consequences should be included in those records. And by creating legally defensible documentation, you should always aim to be objective, stick to the facts, avoid opinions. This is very difficult oftentimes when you're dealing with employees and there are certain expectations or disciplinary things that are happening. But we recommend, again, as Jeff mentioned earlier, ensure that everything that you're writing, just assume that it's going to be read in court. And that's the easiest way to be objective, stick to facts, and avoid any opinions. Um, be consistent, so apply discipline uniformly across employees. This can help mitigate any human rights complaints or any fairness complaints that come through. Be timely, document issues as they happen, not weeks later. This can address the condoning nature of a with cause termination. If an employer doesn't address something right away, that could be seen as condoning it. And then get employee acknowledgement every time that you meet with them to discuss something. So, if possible, have them sign warnings. If the employee refuses to sign, document that as well. On this date we met, they refused to sign. Yeah, just document everything is always best case. And so now, best practices for actually carrying through these conversations. Whether you're issuing a warning or terminating an employee, how you handle the conversation really does matter. And here are some guidelines on how to do it appropriately, how to do it right. Prepare for the conversation. Review your documentation, review your policies, review your employment contract for that particular employee. Have a plan or a roadmap of what you'll say. Be clear and be direct. And then, if possible, have a management side witness present, especially for termination, but in all circumstances is really beneficial. Deliver the message professionally. Stay calm, stick to the facts. It's likely a high emotional situation. No one likes to talk about not doing well or making mistakes or doing things of that nature. So it's going to be a little bit emotional, but be respectful and be firm. It's not a debate, and keep it brief. Don't over explain. Stick to the notes that you prepared. Again, managing emotions and mitigating conflict. So expect emotional reactions, and it's your job as an HR professional or management or representative of the employer to stay professional in those scenarios. You can listen, you can provide comfort or understanding, but don't argue and don't justify any decisions. And definitely prepare to offer some next steps. So support, resources, or if it's a termination, final pay details as well. And then in circumstances of termination, handling final pay, benefits, and references. Ensure that you're being compliant with ESA termination pay amounts and rules. Clarify benefits, pension, clarify any other details. Only provide a reference if it's fair and accurate. We often see employers providing a confirmation of employment, which is a nice middle ground, so that you don't have to write a glowing recommendation for someone, but you can provide them with you know this piece of documentation that would confirm their employment with you. Um, so if handled properly, discipline and termination don't have to escalate to a legal dispute. The key is fairness, clear communication, and strong documentation on the part of the employer.
And really, just to finish this thought, I guess, or this element is what you really want to do if you have to terminate an employee, assume they're going to go and get an employee side lawyer. And what you want is to have that lawyer look at the case and say, I don't see merit in a dispute. I can't argue this because your employer did everything right. But that's ultimately the goal. And that if you go back to step one, that should be the foundation for all of your actions, whether you're disciplining, whether you're issuing performance improvement plans. If you do it right, you limit your risk. And I think we're good at the end. We don't have very much time for questions, and I'm just looking at the question. It looks like we did what I would say is a fantastic job because there are no questions.
Yeah.
But if anyone has any right now, we're happy to field them. If not, if something arises, once we've finished the presentation, feel free to get in touch with us. We're here to help. Anything we can do to make your life easier is our job.
And while we're waiting for questions, I'll just kind of relay a thank you for joining today's webinar. We're very grateful for you to have joined us, and we're very happy to be here talking about this. Thank you. Our next session will be on March 19th, 2025 at 10:30 a.m. So feel free to follow up after the presentation if any questions come up. And again, for more info, visit springlaw.ca, follow us on social media or YouTube, or sign up for our newsletter to stay updated. And yeah, we'll see you at the next webinar.
Thank you.